Hi everyone, Yasmin Abdelhak Barker here, and we're going to talk a little bit about paternity. Really, what do I do if the mother of my child or the father of my child and I are not married? How do we proceed within the legal system with establishing paternity and also obtaining orders on custody, parenting time, child support, and everything else that might fall under the umbrella of child-related issues? So in Indiana, if you and the child's father or mother are not married, then the father is going to have to take just an additional step to establish his paternity over the child. And this can be done in a couple of different ways. One of the more common ways is immediately following the birth of the child at the hospital, they might present you with a stack of documentation, and in that stack might be what's called a paternity affidavit. It's really important that you understand what this document is, and so it may even be worthwhile consulting with a family law attorney before the birth of your child, because the paternity affidavit serves to establish paternity, and it's a document that the two of you are going to sign voluntarily, willingly, and under penalties for perjury. And they're pretty hard to go back on once the two of you have entered into it freely. So it's really important that you understand when you sign that paternity affidavit, you're in. And so, again, you might want to speak with a family law attorney before you do so. If a paternity affidavit has been signed and executed by both parties, then the next step will be to open up a case filing within the county where you and or the parent reside. Oftentimes that's the same county. And you'll be starting a new paternity matter. And you'll want to file a petition to establish paternity. And if there is an affidavit, you might simply attach that to your filing to let the court know that paternity is not really the issue here. It's more a matter of custody, parenting time, and child support. The first step is always going to be establishing paternity, whether that's through the affidavit, whether that's through requesting DNA testing, which is a possibility, or if the parties can stipulate, which is a fancy word for agree, that this individual is father, there's no doubt about it, and so we'd like to move forward with the rest of the process. That is usually the three ways that it's going to play out. And so, again, if you have that paternity affidavit signed, you're kind of ahead of the game already, but you still want to present that documentation to the court so that the court can, step one, establish paternity, and now move into all of the other issues of custody and parenting time and child support. And even if you and the other parent of your child are no longer in a relationship with each other, that doesn't mean that you're without any kind of recourse with regard to your child. You want to make sure that you speak with a family law attorney as soon as possible in the event that you and the other parent of your child end the relationship. You don't want things to end on bad terms to the point where now you're going a long time without seeing your child. So give us a call if this is the situation that you're going through. I'd be more than happy to speak with you about that or any other family law questions you might have.